by all means, your attorney better wait. Otherwise, you have an issue with your attorney there.
I did the pre-requirements, we filed the petition, and I'm going to go to a meeting. What's the meeting of creditors?
Well, the meeting of creditors is required under the bankruptcy code. It's an opportunity for a trustee to examine you under oath to make sure that you're entitled to a bankruptcy and to make sure that there are no assets which can be taken, administered, and paid towards the creditors. And of course, the creditors have an opportunity to show up at this meeting and witness it, ask a few questions, possibly tell the trustee about something that they may know about the debtor. For example, if there's property in Wisconsin that was not disclosed, or an old Corvette that miraculously didn't make the schedules. It's an opportunity for the trustee as well as creditors to examine the debtor under oath. And creditors can also set up their own meeting. That's called a 2004 examination. In some cases, the trustee does not have enough time to let the creditor ask questions, forever. And the trustee will say, look, bring your own motion, have a 2004 exam, you can examine the debtor on your own. I'm convinced that the debtor has no assets, in my opinion.
I've actually been on either side of that. I've represented a debtor in that situation. I've asked questions. Hasn't gone on for a long time, just a few kind of basic kind of things there.
I think it's important to note, too, on this topic that bankruptcy is for the honest debtor. So as long as the debtor is being honest and has made a full disclosure and is not hiding anything and hasn't committed any kind of fraud, that debtor should not worry about any of these procedures. It's the dishonest debtor, the one who has done something possibly shady or non-disclosure or something of that nature, maybe taking advantage of a creditor, taking a loan out in false pretenses. That's the debtor that should worry that either the trustee, the U.S. trustee, or a creditor can bring a motion objecting to the bankruptcy either in part or that death sentence in its entirety.